Welcome to Chenaur Injury Lawyers YouTube channel. I am here today with Leandra Tiller, a seasoned personal injury attorney. Today, we're delving into the key elements of building a strong slip and fall legal claim. Let's get started. Slip and fall accidents can happen anywhere, but how do you determine if your incident could lead to a significant legal case?
Well, the strong foundation of any slip and fall case is going to depend on whether the property owner knew about the hazard in question, the hazard that resulted in your fall. Because if they did, then they've got a duty to you, and in many cases the general public, to either warn about that hazard or to fix it.
How do you determine if a property owner was negligent in maintaining safe premises?
Yes, so if the cause of your fall was the result of a hazard that was known by the property owner or should have been known by the property owner if he or she had done proper inspections, then there's a good chance that they would be liable for any injuries caused by a fall.
How can individuals determine if they have a viable slip and fall claim?
So one way to determine whether your claim is likely to be viable is whether or not the hazard that you slipped and fell on was obvious or not. The law expects people to be aware of their surroundings, and if there's an open and obvious hazard, like a huge hole in the ground that you just couldn't miss and fall in it, that's probably not a viable claim. However, something like a clear puddle of water that's easy to blend in to the surroundings, if you don't see that, and it's very easy not to see that, and you slip and fall, then that's more likely to be a viable claim.
Why is it important for the hazard not to be obvious?
Well, like I said, the law expects people to be aware of their surroundings and to take precautions to avoid them when possible. So, for example, going back to that open hole in the ground, if there's no way for you to get around it, that's actually an exception to the rule. But if you can walk around it, unfortunately not.
What role does comparative negligence play in slip and fall cases?
So comparative negligence can potentially reduce the amount of your settlement. The defense attorney will likely argue that if you were X percentage at fault, the amount you should otherwise recover would be reduced by X percentage.
What steps should someone take immediately after a slip and fall incident?
Right. Well, the first step you should take, if you're able, is to photograph the scene, the hazard, any visible injuries that you might have. And the second step would be to reach out to help. Obviously, medical treatment if you need it immediately, but also to an experienced attorney who can start guiding you through the process right away.
Why is documenting the incident crucial for a slip and fall case?
Yes, so oftentimes evidence that could be crucial to the case that exists at the site of the fall will disappear or be moved during the cleanup after a hazard. So it's really important to take photos to document things that might otherwise be lost or might somehow change within a few days.
What is necessary to prove in order to win a slip and fall case?
So you want to prove that the property owner either knew about the hazard before the fall or should have known about it if he or she had done a proper inspection.
How can individuals ensure they receive fair compensation for their slip and fall injuries?
So for that, they would definitely want to consult with an experienced personal injury attorney, because there are a lot of aspects to this law, and an experienced attorney will be able to guide you through it, as well as give you a proper evaluation of what your case could be worth.
Can slip and fall cases be resolved through settlement, or do they typically go to trial?
Yeah, so they can definitely be resolved through settlement, and I will say the majority of cases are resolved through settlement. Now, sometimes that settlement comes after a lawsuit is filed. However, it's imperative to treat every case as though it's going to trial and it's properly prepared just in case.
How long do you have to file a slip and fall lawsuit after an accident in the state of Washington?
So the statute of limitations for a slip and fall in Washington is 3 years. However, there are some exceptions to that rule. The big ones being government claims as well as claims happening on tribal land. And for tribal land, the biggie there would be happening at a casino or around a casino area. For those, the statute of limitations can vary greatly. We've seen some as short as 6 months. So if you have a claim that either happened on government land or tribal land, it's important to reach out to an attorney much sooner than you otherwise would.
Great. That is all the questions I have. Thank you, Leandra, for shedding light on the intricacies of slip and fall legal claims. Remember, if you've been injured due to negligence, seeking legal guidance is your first step towards justice. If you found this information valuable, don't forget to smash that like button and subscribe to our channel for more insightful discussion on legal matters. Until next time, stay informed and stay safe.